Right, well, welcome everyone to this first podcast on Japanese law and context. We're delighted to have with us a leading specialist of civil justice, particularly civil procedural law, Professor Yoko Tamura. And I'll ask her to introduce herself in a minute, but I'm Professor Luke Nottage from the University of Sydney Law School and co-director of the Australian Network for Japanese Law, ANGEL. So Professor Tamura, could you just outline your current affiliation and any other interesting past or current roles?
Yes. Hello, everyone. I'm teaching Japanese civil procedure at Tsukuba Law School in Tokyo since 2013. And previously, I was teaching the same subject at Ritsumeikan University in Kyoto, mainly for undergraduate students.
Oh, thank you. And so the main field of Japanese law you've been co-teaching for the Kyoto and Tokyo seminars in Japanese law hosted by ANGEL and by Ritsumeikan Law School has been civil justice. Is that right?
Yes. I've been co-teaching civil justice and law with outstanding Professor Luke Nottage here for the Kyoto seminar. It is really good opportunity to deepening my understanding Japanese law, discussing with the people from other countries.
Yes, thank you. It's been a privilege to be co-teaching with you, Professor Tamura. And so what have you found to be the most important or interesting features of your field of Japanese civil justice from a comparative law perspective?
Well, I would say the most interesting feature of civil procedure is a kind of law of evidence, comparing with other jurisdictions such as American law and Australian law. For example, the standard of proof in Japanese civil case are the same as German law and French law, different from one of the standard in common law countries. In Japan, as a continental European law country, high standard of probability, even in civil case, it's necessary. That means you should prove more than 75% or 80% probable that it is true. While in common law countries, you can prove the fact more likely than not using the principle of preponderance of evidence, since in those common law countries, jury, ordinary persons should understand and use the standard to judge the case. So the standard must be easy to apply. But in Japan and the European law countries, professional judge decide the case so that they could use more complicated standard, and they think strict standard would be better to guarantee the truth. Though in common law countries, the preponderance of evidence, more likely than not, would be considered better standard for dealing with a fairness of the parties. In Japan, the criminal procedure more likely, prosecutors and police could investigate before trial, and they have much more powerful and power, and so they could use the power. But in civil case, parties should find the facts and evidences. So they have no such good means to find the truth from the other side, to get some evidence from the other side. So it is quite difficult for people to prove in the civil case, but still Japanese court or European countries require people to prove as a high standard. So maybe in common law countries you could prove easily. So maybe common law country standard are just good for people. So even you may say Japanese people are meticulous or precise, likely to prefer precise standard. but it doesn't work well sometimes. So it's kind of, interesting thing to discuss in the class.
Have we found many influences from abroad in your field of civil procedure and so on, particularly in recent years, apart from obviously the heavy influence of German law, which you've already touched on, but do we find other influences starting to impact on Japanese civil justice systems?
Well, not so quite. As you said, there are many influences from German law in early 20th century, and some features from Austria. Sorry to say, but not from Australia, but Austria in Europe, because at that time, Germany and Austria are such an empire state that governmental power are very dominant against citizens. So Japanese, government at that time preferred such type of procedure, and the emperor really governing the country, and food court power also strong. But maybe after the World War II, American laws have influenced a lot to Japanese laws, mostly to Japanese constitution, criminal procedure, and corporate laws regarding clauses of human rights. But Japanese civil procedure are not quite relevant to human rights. So the basic features have been remained most same as before until now, which means it keeps German style.
So what have been the biggest areas of change, or else maybe surprising areas where there's been no change in civil procedure law in Japan?
Yeah, the same answer as the previous one. I would say again, not a quite change has been existed in Japanese civil procedure. Of course, little by little, there have been reforms to improve for the convenience for the people. Kind of pre-trial procedure before open trial at the courtroom has been improved to facilitate the proceeding. But I'm not so sure the outcome or improvement really not quite existed or happening.
Right. What about the question of delays or time taken to decide the case, particularly at first instance, the trial judge stage, or else at appeals? Have there been many changes in those results in terms of case disposition times?
Oh yeah, well, in that sense, yes, positive. I mean, we could reduce the time within 2 years, even in a big case, because of we try to kind of pretrial proceeding, using the pretrial proceeding to facilitate to find the truth, because we say kind of issue arrangement. That means parties should provide what kind of issues they have, and then they just focus. They are focusing on the issues, really, disputing. So. So that's why even in big case could be resolved in 2 years in Japan right now. So the delay of the court proceedings has been reduced.
Is it something law in books in the Code of Civil Procedure, or is it more just a sort of courtroom practice that's developed with the judges and the lawyers? Or is it a combination?
Yeah, maybe combination. Especially mindset of the lawyers and judges have been changed too, because before, busy lawyers would like to take more time to prepare for the next trial. So they just okay with the kind of, slow proceedings. But now court enhance the power to take more charge to control the proceeding, and lawyers should be more
Yes.
hurrying
Yes.
to prepare for the documents.
So let me ask now what you think will be the most important transformations in civil procedure law over the next few decades, and why?
Well, I think it's the same as other areas of law, but electronic techniques and or IT will definitely great influence on the civil procedure as well as more and more in the next decades. A virtual trial using such as Zoom conference would be maybe possible in the near future. And another example, the court would allow using e-evidence such as data files, as well as emails, Twitter, YouTube, and other social medias instead of providing paper documents. And court documents such as claims and judgment would also be kept in electronic devices, sparing a huge number of papers. Therefore, there would be much more paperless, court procedure and virtual trial using electronic data. I hope electronic technology would enhance the chance of access to the court and justice for the people.
But has the COVID-19 pandemic forced the Japanese courts to move more quickly already to e-filings and virtual hearings, remote hearings, and other forms of electronic-based trials and judgments, or is that still something that's going to be happening in the future?
I think so, but the influence from the COVID-19, not so quite, I suppose. Of course, such a remote hearing or conference is used more for the party living far away from courthouse, but still we need to some change of rules because anyway, it's still lawyers should go to the court anyway. So party can be stay at home, but so not so much differences because of the COVID-19. Well, I suppose in future, maybe in the world, online kind of online dispute, resolution system and those software will be more developed so that people could foresee the outcome or result of the court decision using such kind of AI technique. So people will have more, kind of chance to settle or compromise at reasonable amount of money in a civil case before coming to the court or even before asking or counseling a lawyer. So maybe less lawyers would be necessary and less court procedure and maybe less law schools necessary would be used in the future. So I'm just a bit, nervous about this kind of future, but anyway, good for people, I suppose. But maybe lawyers, the role of lawyers must be changed to, prevent the case more than, resolving the dispute after. So I think we have to think about the, role of lawyers too.
No, that's a very good point, and we already see this if we look back over the last 20, 30 years, some transformation of the legal profession already with the lawyers doing more transactional work and not just being primarily barristers or professionals that focus on court work. But if we can develop algorithms, even artificial intelligence to try to help parties and some types of lawyers, but resolve disputes before they get to the courtroom, then the role of lawyers will have to adapt as well. So thank you for that forward-looking observation, Professor Tamura, and thank you for joining us for this podcast.
Well, I'm very honored to, be interviewed today. Thank you very much, Professor Nottage.